how to brief a case. I guess the first question is, what is a case brief? We actually use the word brief a couple different ways in law. One way is the case brief, and that's what we're going to be talking about here. The other instance of using the word brief is referring to an appellate brief that attorneys will prepare for a case on appeal, a very lengthy document, or it might be a brief of authority that attorneys would prepare in support of a motion that they're going to argue in front of a court. But here we're talking about the case brief. It's a brief that is prepared typically by law students, paralegal students, other people studying the law. And I suppose it might have some application in the law office where a lawyer might tell one of the staff, go brief this case for me. So in that context, we're talking about a case brief. So what is a case brief? It's a summary of the most important points in a court decision, a particular court decision. Usually that's going to be an appellate court decision. And we call it a brief because it's brief, typically a page or less. Now, why do we brief cases? Why will we brief a case? Well, to understand how the principle of law that case is all about, how it's being applied to a particular set of facts. Try to understand what a case stands for. In law school, we use this as a teaching method, and it does have a very practical application to understand what that case is all about. The first part of a case brief, is going to be setting out the facts, the important facts. You have to distinguish what facts really have some sort of application or bearing on the court's decision, that the issue that's going to be in front of the court. And we'll talk about issue in just a moment. But in the case brief, we disregard all facts that really don't have any bearing on what the case is all about. And we also have to recognize that the facts that we are dealing with in the court decision that we are briefing, in that court opinion, those facts were developed at the trial court. So the appellate court is saying, well, these are the facts that are in front of us. And appellate courts don't refight the battle on facts. They only deal with questions of law. So keep that in mind as we go through this. Now, the next part of the case brief is going to be the procedural history. What court issued this opinion that we're reading, that we're briefing? How did the case get to that court? Did it come up from the trial court on appeal? Did it come from another appellate court? Now, this procedural history is typically not an important part of the case brief unless the case turns on something that happened in that procedural history. And in fact, some instructors, some teachers will even say it's not necessary for our purposes to prepare or include the procedural history, but some do. Okay, the issue. This is what is really the difference between lawyers and lay people here. Whether you can spot the issue and articulate the issue in a question. Now, fortunately for the students and people who read these cases, the courts typically are very helpful in helping us understand what the issue is. Because they'll start with the word, they'll identify it for us. The issue before us today is whether, so you want to look for that word whether as you read the court opinion. But then, and so frequently the court will state that legal issue in a question. So it's the question that's presented to the trial court, the question that the court's going to be struggling with, the question that the court's going to have to decide. And it's a legal question. It's a legal issue, not a fact issue. We've already dealt with the fact issues at the trial court, so we're stating what is the legal issue, what is the issue over the interpretation of the rules that's going to decide this case. And of course, the answer to that question will determine who wins the case. Now, in some briefs, we might put the holding of the court. You might see, wonder, well, what's the holding of the court? And it's usually a very brief 1 or 2 word answer to this question. And the answer is either yes or no. So question would be whether or not an accused, a person accused of crime is entitled to legal counsel at trial. Okay, that was basically the one of the questions in the Gideon versus Wainwright case. And the answer would be yes or no. And in this case, the court said yes, they're entitled to assistance of counsel at trial. So that's just very brief. Now, some teachers, professors, instructors say just work the holding into the rule. They're really referring to the IRAC method of the facts that issue the rule, and then the other 2 letters we'll look at in just a moment. But the rule, what is the rule? That's the next section. Well, that's the rule of law that the court used to decide the case. And there may be more than one rule that's involved. It depends on how complicated or the case may be, how many issues may be involved. There may be a couple different rules that they have to consider depending on what the facts are. And so that's why it's important to include in your brief at the very front what the important facts are. See, everything ties together. And the court will discuss these rules. And as they discuss the rules, that will help you in the next section of our brief. And that next section is the application. Sometimes it may be called the analysis or the reasoning of the court. And this is frequently viewed as the most important part of a case brief, because we are explaining or looking at why the court ruled the way it did. We are taking the facts that we set out earlier in the brief. We're taking the rule that the court used and applied in the earlier part of the brief, and now we're explaining why they did that. And the courts frequently will state what each party contends. Appellant contends this. Appellee contends that. And then frequently the court will say what they find sound or not sound about those conflicting arguments. So that will help you understand and be able to identify how the court is applying the rule to the facts. And that's what this section is about. And then, of course, the last section of the case brief is the conclusion. And it's basically a short statement saying that the court affirmed or the court reversed the case and held for the appellant, appellee, plaintiff, defendant, however the parties are being designated. So it essentially is saying who won and who lost. And so by using this case brief, we can have a better understanding of the principles of law that we are studying.